Welcome to this presentation on South Carolina Property Tax Appeal 2026. If you own property in South Carolina, your property taxes are based on the assessed value determined by your county. Each year, the county assessor mails notices of assessment showing your property's market value and taxable value. Under South Carolina law, specifically SC Code Section 12602510, you have 90 days from the date of the notice to file a written protest with the South Carolina Department of Revenue. As stated on the official website of the South Carolina Department of Revenue at dor.gov, the protest deadline is strictly enforced. This presentation walks through every step of the SC property tax appeal process, the key deadlines, and how to protect your rights. The single most important rule in the South Carolina property tax appeal process is the 90-day protest deadline. Under SC Code Section 1266-2510, a property owner must file a written protest within 90 days of the date listed on the proposed assessment or notice from the SCDOR, as stated on the official SCDOR appeals process page at dor.gov/notices-compliance/appeals-process. This deadline is strictly enforced. If you fail to file within 90 days, the SCDOR will make its final assessment and begin collection activities. You can file your protest three ways: online through My Doorway at dor.gov/mydoorway, by submitting a paper form C-245, or by writing a letter. Filing a protest stops all collection activities. South Carolina law requires counties to mail property tax assessment notices by January 15th of each year. This is the date when the 90-day protest clock typically starts for county-level assessments. The notice must include the prior year's appraised value, the proposed new appraised value, the estimated taxable value, and detailed information about your right to appeal. Important: the January 15th deadline applies to county assessors sending notices, not to your protest filing. Your protest deadline is 90 days from the date of the notice you receive. South Carolina does not tax 100% of your property's market value. Instead, the state uses assessment ratios. SC Code Section 1243-22 establishes different assessment ratios for different classes of property. Residential property is assessed at 4% of market value, commercial property at 6%, manufacturing at 9.5%, and business personal property at 10.5%. Understanding these ratios is essential to calculating whether your assessment is fair. The South Carolina Department of Revenue's appeals process has 5 main stages. Stage 1. The SCDOR issues a proposed assessment. Stage 2. You file a protest within 90 days. Stage 3. A division representative reviews the protest. Stage 4. The appeals section conducts a substantive review. Stage 5. The litigation section issues a department determination. Each stage provides opportunities to resolve the dispute. If you disagree with the department determination, you have 30 days to request a contested case hearing before the South Carolina Administrative Law Court. Before your case reaches the SCDOR's appeal process, your first stop is typically your County Board of Assessment Appeals. Each county must have a board to hear property tax disputes. The board is composed of county residents appointed by the county council. You have the right to present evidence, including comparable sales, photographs, and appraisal reports. If the board decision is unfavorable, you can appeal to the SC Administrative Law Court within 30 days. How much can a successful property tax appeal save you in South Carolina? SC's effective property tax rate is approximately 0.57% of market value. But even a modest reduction can save you hundreds per year. Example: a $350,000 home with a 10% reduction saves about $600 per year. Over 5 years, that is $3,000 or more. In high-growth areas like Charleston, Greenville, and Myrtle Beach, the savings can be even more significant. Property tax exemptions are the most effective way to reduce your tax bill. The homestead exemption under SC Code Section 1237-250 provides a $50,000 exemption from the market value of your primary residence. To qualify, you must be 65 or older, or permanently and totally disabled, or legally blind. Disabled veterans may qualify for a complete exemption. Agricultural land may be assessed based on use value rather than market value. Here is your action plan. Step 1. File your homestead exemption. Step 2. Watch for your assessment notice by January 15th. Step 3. File your protest within 90 days using Form C-245 through My Doorway at dor.gov/mydoorway. Step 4. Prepare for your hearing with evidence. Step 5. Appeal to the Administrative Law Court within 30 days if needed. Thank you for watching. Visit dor.gov for more information. Your appeal rights are time-sensitive. Act now.